here, Family Law Project. Thank you for joining. And just started about a minute late. I was waiting for a few more people to join on. We've got lots of people live. So please comment in the chat box where you're from. It's great to have you here. We've got a real mix of people today. So you might be watching this back on YouTube, but we're also running this live webinar. We've got lots of service providers, community legal solicitors, some private lawyers, thank you for joining us too, and of course people who have separated and you're trying to navigate your matrimonial or property de facto property settlement, and what a difficult time that can be. So I've got a couple of lawyers from our office today are assisting in the chat box. Any questions, they'll attend to them. So thank you guys for assisting. Just the first slide there, that's my bio. And you might notice the slide's not as sexy as it normally is. I've been up since 4:30 trying to fix my slides, and they're not as nice as I would like them to be, but rest assured a nicer looking handout will be dropped in towards the end of this webinar. So I'm just going to bear with me while I'm just getting used to, there we go. So a general caveat that we give at the start of these webinars is that this is not specific legal advice. Every matter is different. Your matter is unique, and keep that in mind, okay? Also, as I mentioned, we've got all different sorts of people who've tuned in today, and I'm going to be speaking as though I'm speaking to the client, to the person who's separated. So I'm going to be using expressions such as your ex-partner, your matter, and so on. So keep that in mind, but I'm doing that purposely, okay? And if you are a legal advisor, or watch out at the bottom, look at the bottom of the slides for references to case law and legislation, and you might want to follow that through OSLI as we go along, and no one else will really care about that except for you guys. So, all right. Every matter is different, and just keep that in mind. So what we covered in previous webinars, and if you've not seen our previous webinars, we've got a YouTube channel which you can look at, and there's some really good resources there. So I know my staff will drop the link in the comments, but what we've covered in previous webinars are things such as, you know, types of relationships. What are the types of relationships? What is a property settlement? What are the time limits? We did a whole session on immediate and practical steps that you can take when you first separate. We've spoken about injunctions, property injunctions and caveats, and also the four-step process and what the law says about how to divide property. So we're not going to repeat that today. I will very, very quickly just go over a little bit of it. But if you want to go into more of a deep dive around that, then you can look at our past webinars. What are we going to cover today? Well, today we're going to look at this sort of practical, the 7 ways that you can resolve your property settlement matter. So looking at community-based mediation, and where I've got FDR there in brackets, that stands for Family Dispute Resolution. And I know we've got quite a few FDR practitioners that have joined us today, so thank you for joining. You'll know all this, and you'll probably know a lot more than I do. So if there's anything that I say along the way that you think, oh, I'm not sure about that, Shaya, or perhaps you want to add a bit, then please do so in the chat box, and please forgive me. So community-based mediation, we'll talk about private mediation services and lawyer-assisted mediation services. We're going to talk about legal aid mediation, or FDR, direct negotiation, which might be negotiation between yourself and your ex-partner. And we'll talk about lawyer-assisted negotiation and collaborative law. Then what we're going to go into is, if you do reach an agreement, well, how do you formalise that? And if you don't reach an agreement, how do you go to court, and what does that court process look like? So what we do know is property settlements are complicated. And what is a property settlement? Where it's basically altering your existing legal entitlements and altering your property division. And it's going to be an agreement or a court order that sets out the division and the dealing of the assets of the parties. And it might provide a timeline, like a time frame for property to be transferred, or for a cash payment, or for super splitting, for example. And it can also deal with an agreement or orders about your personal property and division of your debt. And what the law says about property division is relevant no matter what option you're looking at to resolve your property settlement. And the reason it's relevant is because we all use it as a guide. So if, for example, we're going through community mediation, or if you're using lawyers to assist you, they're all going to use what the law says about how to divide property as a guide. So it's interesting actually, what the Federal Circuit Court website says around how to divide property, and I'm going to read this in a second, but it's not particularly helpful. And I think that can be people's general experience with the family law system, is that a lot of the information is not helpful. Okay, so hopefully at the end of this webinar we'll break it down a little. But what the Federal Circuit Court website says is this: there is no formula used to divide property. No one can tell you exactly what orders a judicial officer will make. The decision is made after all the evidence is heard, and the judicial officer decides what is just and equitable based on the unique facts of your case. That's not very helpful, is it? So as lawyers and as mediators, which we'll go into in a second, we need a guide, and the guide that we use is that 4-step process that we used in previous webinars. So again, go back to the previous YouTube webinar to go into a deep dive into this 4-step process. But doesn't matter which option you take about these, or in relation to these 7 options we're about to go into, every single one of them is going to use this as a guide. And you're always going to identify and value the asset pool. And you're going to look at what the assets are, what the liabilities are, whether they're joint or sole name. You're always going to look at what the financial contributions of both parties were and what the non-financial contributions were. And you're always going to look at the future needs of the parties. So what's your health like? What's your ex-partner's health like? Who's caring for the children? And what are your income or earnings? So that's the basis for whatever option you take. Now, here's an example of my poor slide for those that are hopefully looking at the slides. When you get the handout, these pictures that I've spent hours obtaining illegally off the internet will be more visible. Okay. The point of this picture is that you've got 7 ways to resolve your property matter. Every option is different. However, they're all going to have things in common. Whichever approach you decide is best for you, you're going to find there are some commonalities. So what do all the options have in common? Let me talk through that. And while I do that, I'm going to minimize myself so you can spot the difference whilst I'm talking. So what do all the options have in common? Most matters are better resolved out of court, and hopefully you'll appreciate that by the end of this webinar. Most matters can be resolved out of court. Trying to resolve your property matter is difficult, and I've just given you before that Federal Circuit Court website quote, which was not particularly helpful. But also the Australian Law Reform Commission back in 2019, back then they're recommending that there be some sort of clear framework to help couples trying to navigate the system. But to be frank with you, not much has changed. The other thing that they all have in common is, regardless of the approach that you take, we're all going to use that legal framework and the guidance of the Family Law Act. And we're always going to use that 4-step process, no matter if you're a mediator or a lawyer, or if you're trying to negotiate your property settlement yourself. What else have they got in common? And hopefully you've moved on to this next slide now. I don't know how many differences there are in the two pictures, and I must admit that I was getting a bit square-eyed trying to put these slides together, so I haven't done this one myself. So perhaps chuck in the chat box how many differences there are. What every single property settlement matter will have in common is that you're always going to try and identify and value the asset pool at the outset. So when you're identifying the asset pool, you're looking at things like the family home, any investment properties, shares, super, money in the bank account, any businesses, cars and household contents. And then when you're looking at liabilities, it's things such as debts, mortgage, borrowing, loans. You might have some credit cards or store cards and so on. So again, previous webinar gave some really good tips on how to value the asset pool. And I've also just written a book, actually, Secrets of a Divorce Lawyer, which sets out so many tips on how you can do that as well. The other thing that every single approach will have in common is this expectation of the family law courts around what's called pre-action procedure. And the legal advisors will know a bit about this, or should. And even if your matter's not going to court, we use this what's called pre-action procedure as guidance to really try and negotiate matters. And the pre-action procedure requires parties to make a genuine attempt to resolve matters before they go to court. There's this expectation that you're going to make those genuine attempts to avoid court. And in fact, the family court requires you to try alternates such as mediation and so on before you're even allowed to apply to that court for orders. So the objectives of this pre-action procedure is really to do as much of the pre-work as possible in the event that you have to go to court, so document exchange and so on. Trying to get things done a bit more quickly and a bit less stressful than court, and also to narrow down the issues. So even if you do use these other options, but they've not been successful, and then your hand is forced to go to court, at least hopefully you've narrowed down the issues and you can approach court in that way. So the other thing the Federal Circuit Court website said is this: it's the expectation of court that people involved in family law disputes will only make an application to the court where there's no other readily available means of resolving their dispute. And they make reference actually to, when you're trying to use other options aside from court, it gives you greater control of your own situation. As always, there's some exceptions, exemptions. So the type of exemptions are, for example, where these other options I'm about to go into might not be suitable and where court is appropriate. So these sort of matters are where your matter might be urgent. You might be looking at injunctions, and I spoke about injunctions in details in another webinar, but injunctions are things such as, for example, sole occupancy. So someone's left you're both living in the family home and you really need to have the other person removed for various reasons, sole occupancy. So that might be urgent. If there's family violence, then you're not expected to take these other approaches. And also time limitation. And time limitation is around the time limits that you have to initiate court proceedings. So the Family Law Act sets out these limitations, and generally speaking, you've got 2 years from the date of separation of a de facto couple or 1 year from the date of divorce order to apply to the court for court orders. Now, if you've not been able to reach an agreement using these other methods we're about to talk about, then you might need to get an application in quick smart to the court. So that might be an exemption to do so. And we do lots of those actually at our office for what's called like a preservation application to preserve the client's interest. Oops, just enlarged myself instead of the slide. Sorry about that. Alrighty. So the one last thing that all of these approaches have in common is what's called discovery, or the exchange of documents. So doesn't matter if you're negotiating or if you're using a lawyer to help you or a mediation service, there's this expectation that every single approach there'll be discovery or exchange of financial documents. Type of things we're talking about are things such as tax returns, bank statements, any appraisals or valuations that you've had, any trust deeds, business activity statements, and so on, superannuation statements. They all need to be exchanged, and you both need to be satisfied that you're aware of what the other party's financial position is, and you're aware of all the assets that you both have. Rightio, so that's all the commonalities. Let's delve into number one. The first way to resolve your family law property matter is community-based FDR. So community-based mediation. And what we're talking about there is they're sort of government-run or funded low-cost or no-cost mediation services, and places like Relationships Australia, the Family Relationships Centre, and Centrecare. And I know we've got some people from Relationships Australia who've joined us today. So these mediation services, historically, they were frequently and still are frequently used for parenting matters to try and resolve issues around children, where children live, and how much time they spend with both parents. They're now being used as well for property settlements and to try and help parties to reach an agreement about their property division. They're run by an FDR practitioner, and FDR practitioners, they're nationally accredited, they're independent, which is really important, so they're not acting for you and they're not acting for your ex-partner. They are not able to give you legal advice because they're not lawyers, but really importantly, they're not able to enforce a decision. So you both go into this process voluntarily, and this FDRP or this practitioner can't enforce a decision for you. Okay, so that's really important, and really, I suspect, encourages people to use those type of services. They can be slow to get into though, so that is one of an issue. I'm not sure if it's a bit quicker at the moment with intakes and so on being done by telephone. If there's any practitioners here, if you can just let us know the wait times at the moment, that would be really great in the chat box. This process of community-based mediation is voluntary, so it's not compulsory. And what will happen, well, the aim of it, I should say, before I get into the practicalities of it, the aim of it is to give you a speedy resolution, to avoid court, to help you negotiate, and really to help you take control of your situation rather than putting it in a judge's hands, okay? So going on to the practical sort of issues, and thanks, Trini, for your comment there. No wait in the Riverlands, that's South Australia, that's fantastic. There'll be intake sessions or session, and someone will speak to you and get some background information from you and really identify whether there's any urgent issues that need to be taken into account. So, for example, if you're still living together under the same roof, which can be horrific, if a property needs to be sold and so on, and also just identifying if there's any real issues that might deem the matter inappropriate for mediation. So those intake sessions take place first, and of course you both need to agree to participate. And what will then happen is, if it is deemed suitable, you'll both come together in a joint session, which often is done by a shuttle conference where you're in different rooms, but it really, again, depends on your particular matter. And, you know, some are done by phone at the moment as well, and also by video. So every matter is going to be different. So next slide, in terms of practical issues as well, a really good thing, I think, about family dispute resolution conferences is that they can be done as a series of conferences, and we can see that there might be pauses during the session, or you might have a second or even a third session scheduled, and those pauses are purposely designed for you, for example, to go off and get financial advice if you don't know already what your borrowing capacity is, for example. There might be a pause to go get a valuation of a property, or to get legal advice, which of course is very important at different stages. So those, and one of the big ones is, of course, if you do reach an agreement in principle, pause to go off and get that legal advice to make sure that it's a reasonable agreement. So there are all these different pauses throughout, and it's not necessarily going to be just one session, and every service is different. I've stolen this from Relationships Australia, so those who are from Relationships Australia, I have given you credit down the bottom. This is the do's and don'ts of the community-based FDR. Do be prepared to listen. Do avoid highly emotive statements, and do be open to negotiation. The don'ts are: don't deliberately antagonise your former partner. Don't butt in and talk over your former partner as if you'd do that. And don't maintain a dogged fixed position. So that's kind of the general do's and don'ts of community-based FDR. So that's a brief summary. What I'm going to go into now is number 2, the second way to resolve your family law property matters. And number 2 is private. Oh no, sorry, I haven't finished. Sorry, I'm still going on community. I got ahead of myself. So community-based FDR, it's confidential. So if you do reach an agreement, if it's not written and signed, it can't be used anywhere. And that's really to encourage you to negotiate and reach an agreement. If you do reach an agreement, it can be drawn up formally, and we'll go into the couple of options shortly around how you can formalise your agreement, but it's not going to be done within that service. That's not something that they're able to do. If there's no agreement reached, then you might try again through that FDR community-based process, or you might go into one of the other options that we're about to talk about. In my view, community-based FDR such as Relationships Australia, Centrecare, family relationship centres can be a really, really good tool to help you and your ex-partner get that process started, quickly negotiate and agree on at least what the asset pool is, and really narrow down the issues. So even if you don't reach a final agreement, I think it can go a long way to really help the parties to get on top of things and to take control of things for themselves. So now we can go on to number 2, okay? Next slide. Number 2 is private mediation. So private mediation, the concepts are very similar to community-based mediation. The fact it's private, so they're not government workers. These are privately set up services. They tend to be more costly, or they definitely are for that reason. They can be quicker, although based on the comments in the chat box, it looks as though things are pretty quick at the moment with many of the community services. Can be more costly. They can be quicker in some options there's online services as well. And I found that particularly over the past 12 months, there's lots of online family law dispute resolution practitioners, private services popping up with online services, which can be really useful as well. With the private mediations, obviously a disadvantage might be the cost, but one advantage might be that it's quicker and online. And another thing to know about this service, which we do quite a bit of at our office, is it can include lawyers. So it's very unusual for us to be allowed to be involved in the community-based mediation. But with the private mediations, we can arrange that to be lawyer assisted as well, which can be really great for the client to ensure that they're getting that legal advice alongside as they go through the issues. There are the Commonwealth Attorney General's Office has a list of the qualified practitioners, which, you know, they're required to keep a list and you can find them online. So that's the second option to resolve your property matters. Number 3 is a DIY negotiation. Do it yourself. We see a lot of this, and sometimes it can be a bit of a dog's breakfast, okay? This is where the parties attempt to negotiate directly between themselves, and generally speaking, it's where the communication is quite amicable between the parties. Can be quicker and definitely can be cost effective unless you're making poor decisions around the agreement, which can cost you thousands. I think this can be a good option for some people. And what I would say is that if you are going through the DIY option, arm yourself with as much knowledge as possible. And the fact you're watching this webinar is promising, okay? So link in, watch all our webinars, and I also recommend getting at least some one-off legal advice. There's community legal centres, there's legal aid offices, there's a lot of law firms that offer, you know, complimentary half-hour meeting, for example. Link in with those services if you're going down the DIY negotiation. Do your due diligence. If you're looking at doing this, you should still be doing everything in terms of document exchange, discovery process, making sure that you're satisfied that the asset pool's been identified and valued, and doing all those things. And how does it work? Well, it works however you want it to work. You're doing it yourself. So it depends on you and your ex-partner and the dynamics of your relationship. It can be used in conjunction with another service. So it's not uncommon, for example, for us to be helping clients and then we find that they've been off for coffee and trying to resolve some issues themselves as well. So some people will do it all themselves. It really depends on you, your ex-partner, and your circumstances. And I think in some cases it can be a really useful way to progress the negotiations. The thing I have concerns about is the next slide, because there's a difference between DIY negotiation and DIY agreement, okay? So if you've reached an agreement, and I can see another poll's popped up there as well for those that are playing along. If you've reached an agreement, you may or may not have had some legal advice or some mediation input throughout. It might not be in writing and it might not be legally binding. So I've had clients, a recent one last year actually came to me and they'd been separated for 10 years and he brought an agreement that was written up, signed by them both in the presence of a justice of the peace. And it's essentially not worth the piece of paper it's written on, because there's only a couple of ways to formalise your property settlement to make sure it's watertight. So I'll talk about them shortly. But if your agreement's not watertight and you're doing it yourself agreement without that input, it either might not be watertight at all and you might be leaving your assets open to a further claim down the track. Okay. Number 4. Oh, and I just want to say though, on that, I'm not anti-DIY agreements for parenting matters. I think that drafting your own parenting agreement, if it's a parenting plan or consent minutes of order, can be done without the use of lawyers at times and can be a good cost-saving measure. But when we're talking about property settlements, I feel strongly that you really do need that legal input. Okay. Number 4, and my colleagues are going to hate this slide, lawyer negotiation. So this is another way, the 4th way, to resolve your family law property matter. And similar principles to what we've been talking about, similar guidelines. We're always going to identify the asset pool. We're going to do that discovery document exchange process to make sure there's been a good document exchange. And we're going to consider that 4-step process that I spoke about earlier. So what might lawyer-assisted negotiation look like? Well, it might be things such as meeting with you and writing letters to the other party or their lawyer if they've got one, or it might be putting proposals of settlement to your ex-partner. We might be assisting you in conjunction with a mediation service. So for example, that community-based mediation service, you might get some advice from us and then go see them and then come back to us to check the in principle agreement. We can attend informal conferences with you, and we can arrange informal conferences. For more complex matters, we can get a barrister to come along as well. Those sort of informal conferences is where there's no intake, no independent chairperson or mediator. And really, those informal conferences work best when we've done a lot of the pre-work in terms of identifying the asset pool and narrowing the issues. But there's all different ways that a lawyer can help you to negotiate. And again, it depends on your ex-partner. Sometimes I wouldn't in a million years recommend that to a client because their ex-partner is just going to not engage in that process, and it's just a waste of money. So it really depends on your particular matter and your ex-partner, unfortunately. If you're using a lawyer to help you, if there's an agreement, we can help you draw it up so it's binding, so it's legally binding. If there's no agreement, then we can talk you through your other options, which might include court, which we'll get to shortly. But before we get to that, the internet's so slow. I'm in lockdown at the moment and the internet's not working, and someone started drilling next door and I've had problems with the slide. So all in all, great webinar. Number five, legal aid assisted FDR, legal aid assisted family dispute resolution. So I've popped on there the National Legal Aid website because each state has a different legal aid service. Each state differs. What is common though is, generally speaking, most state legal aid officers do not provide funding for property matters. And again, there's some exceptions, and that might be if you're just dividing up debt, or if it's a very small property pool, or if you're just dealing with super splitting. But generally speaking, you're not going to get a lot of funding from your state's legal aid office for property settlements. Always worth checking though. Also, I'm going to talk about this when we get to the court section, but at the moment, each state has some specific funding in place. It's a mediation pilot, and it's for less complex property settlement matters. So it's where, the equity in the property is between $20,000 to $500,000. So for some of you hearing that 500,000, you'll think, well, that's actually shitloads. But the government has said that's a small property pool. So you might find that you may actually qualify for this legal aid lawyer-assisted mediation in circumstances where previously you'd never have got legal aid funding for your property settlement. So this specific funding's been set up for these legal aid mediations. Your lawyer goes along with you, and it's been specifically set up to address issues where there's been allegations of family violence, or if there's cultural, mental health issues, or a risk of homelessness. You can't afford a lawyer. Legal aid funds you to have a lawyer-assisted mediation, and the principles, again, are similar to the other types of mediation that I spoke about, the private mediation and the community mediation, in that we use the same guidelines to work out what the property pool is, and we do the document exchange and do the due diligence beforehand. That pre-work takes place before the conference. The conference takes place in person usually, depends. Some are in person at the moment because of lockdowns, but conference at the Legal Aid Commission, there's a chairperson there who's a qualified lawyer. Most of the chairpersons there have 20 plus family law years experience, so they're very experienced. And 9 times out of 10, they're done as a shuttle conference. So you're in one room with your lawyer and your ex-partner in another room with their lawyer if they choose to have one. chairperson goes back and forward. The beauty about that is that if you do reach an agreement, your lawyer can help you draft it up and get an extension of legal aid funding to do that. If there's no agreement, then you've had that input and legal advice about what the other options are, which may be court. So really keep this option in mind. If you don't think you'd normally qualify for legal aid, but you might qualify for some funding under this particular project. So we'll go on to number 6. And this is another way that you can resolve your family law property matter. And this is through using collaborative lawyers. Now, I'm not one of these, but it's a really good approach for those less adversarial matters. If your real focus is maintaining a amicable, good communication with your ex-partner, and if you've both got that, mutual goal to stay out of court, it can be a really good option for you. And both parties have to agree to engage a collaborative specialist lawyer. So you both have to have your independent lawyer, and you have face-to-face meetings with everyone present. It's a very transparent process, and it can include other professionals such as financial advisors can come along to property discussions. And if an agreement's drawn up, then those lawyers can help you make sure it's legally binding. One thing to note about this collaborative approach is if there is no agreement, then those collaborative lawyers are not actually allowed to keep acting for you if you need to go to court. So that's all part of that transparency and the mutual goal to resolve the matter. And if you can't, then unfortunately, if you do have to go to court, you're going to have to kind of start again with a different lawyer. But I suspect that's a good way to try and encourage parties to really focus on reaching an agreement. So let's summarise the options that I've just gone through, 1 to 6, the options out of court. And again, there's another blurry picture because my slides didn't work properly, but you'll shortly get the handout. So the summary of the out-of-court options are community-based FDR, private FDR, lawyer-assisted mediation, legal aid lawyer-assisted mediation under that new pilot for 20 grand to 500 grand property matters, do-it-yourself negotiation, do-it-yourself agreement, which I discourage, lawyer-assisted negotiation, or engaging a collaborative lawyer to assist you. So no matter what approach you take, it's always critical to ensure that you formalise any agreement that you reach. And again, this is something that I spoke about in a previous webinar about the importance of formalising your property settlement. Perhaps if someone from the office again can drop the link of the YouTube channel there, so you can go there and have a look at, take a deep dive into why it's important to formalise your matter. But I've put there for the lawyers, you can't quite see on this slide, but it's section 81 of the Family Law Act is that clean break principle. But it's really to ensure that there's no further action later on, that you have that clean break and that you can both move on. It's going to ensure that you're protecting your estate. You're going to protect any future lottery win or family inheritance. You're going to make sure that's no one's going to have a piece of that later. So there's lots of reasons, and check out that the detail in the other webinar. The other reasons are capital gains tax relief, stamp duty relief. Superannuation splitting actually requires a formal agreement. So you can't just write to your super trustee and say, hey, my ex-husband said I can have 50 grand of his super, can you transfer it? Doesn't quite work like that. It needs to be drafted very specifically. The proposed agreement needs to be sent and approved by the super trustee and so on. So that's another reason to formalise, and also to ensure that it's not challenged. So how do you formalise? There's two ways. The first is consent minutes of order, and the other is what we call a binding financial agreement. So with consent minutes of order, I'm just moving to my next slide. Sorry. With consent minutes of order, there are DIY kits, which I do discourage, because when there's an application that's filled out, which includes an affidavit around the disclosure and discovery of exchange of documents, and there's also the written agreement or the written minute that's sent into the court without having to go to court. But these are pretty complex documents. Like I said, it's more complex than a parenting matter. And what we see is if you use a DIY kit and you send off the application and the draft minute to the court, there's a good chance it's going to be requisitioned, and we see a lot of them. So we submit a lot of consent minutes of order to the court for our clients without actually having to go to court. So there's no court hearings, and a registrar of the court looks over the agreement and makes sure that they're satisfied that it addresses that four-step process that I spoke about earlier, and the registrar is satisfied that it's fair and equitable, and then they'll approve it, they'll put the court stamp on it, and it has the effect of a legally binding it's a court order, so you have to comply with it, and there's no coming back for more later. The second option is the binding financial agreement. Very rare that I recommend clients use this option. So the two ways to formalise is the consent minutes or the binding financial agreement. Almost 10 out of 10 times, the recommendation is for consent minutes of order. A binding financial agreement isn't sent to the court, it's not submitted to the court. It requires two lawyers to be giving independent legal advice to both of you. Lawyers have to draft it. It's more complex in terms of its drafting. Lawyers have to sign off on it, sign a certificate at the end. And it's a complex document, and it's more likely to become unstuck. The reasoning behind allowing parties to do a binding financial agreement is basically to say, look, we don't want to be guided by that four-step process. We don't want to be guided by what the law says. We just want to sort out our property settlement as we see fit. It's our property. So if they sent that agreement to the court would say, oh no, hang on a minute, this doesn't fit in line with what we say is a good agreement, a fair agreement, so we don't approve it. So in those circumstances, which is rare, we recommend the binding financial agreement. A recent example actually, had a client come along, the wife and husband had moved interstate, and she was living in the matrimonial property. There was about 500 grand equity in the property. And for whatever reason, the husband said, look, I'll wipe my hands of it, not interested, you have the house, I'm going off, I'm starting afresh. So I said to my client, that agreement will not be approved by the court because it doesn't meet those four-step, it doesn't address the four steps. It's not fair and equitable. It's not fair for the husband. So he had a lawyer. So I said, well, right, let's get a binding financial agreement drawn up because the court's not going to approve it, but we can draw it up that way. So it's quite a rare example of why we would put the client to that additional expense of a complex binding financial agreement. Almost 10 out of 10, it's going to be recommended for consent minutes of order. So that's 1 to 6. Number 7 is when there's no deal, what to do when court's needed. So I guess one of the things to really stress at this point is that if court is needed, and if you have done some of that other work, you've already done some of the groundwork. So hopefully you'll save in terms of legal expense and stress because you've already been negotiating, attempting mediation, attempting negotiation through lawyers, whatever it is. You've already attempted to identify the asset pool. You've probably exchanged some appraisals and valuations, and you most certainly would have exchanged documents and discovery financial material. So if you have to go to court, at least attempting some or, one or some of those previous options, there's still going to be some benefit to that. Sometimes you will go straight to court if it's urgent. Like I mentioned, if you need an injunction, if your time limit's coming up, if there's family violence. But if those things don't exist and you've already attempted other ways, at least you've gone some way. Which court? As if the system's not confusing enough for you. Which court are we going to use if we have to go to court? So there's two courts that deal with property matters in Australia, and they both use the same principles of the Family Law Act, and I've put the section there for the lawyers to look at. Family Court of Australia and Federal Circuit Court. Oh, and I must say Western Australia is a little bit different, okay? But they'll be aware of their Family Court Act and court, which is a bit different. But either way, the Section 79 sets out that, both of those courts are able to make orders altering property. Family court is for more complex family law matters. For example, there might be more than one party. There might be complex trust deed issues. There might be complex corporate structures or issues around super. But the reality is that the Federal Circuit Court hears 90% of all family law matters, 90%. So almost all of our property matters, in fact, almost all of our property and parenting matters will be initiated in the Federal Circuit Court. So just keep in mind, though, whichever court, the same principles are going to apply. But for most clients, it's going to be the Federal Circuit Court. So I'm just going to touch on a couple of the property lists that are available in the Federal Circuit Court that might be of assistance for you. So if you've filed a property application with the court and you're under a discrete property list, in other words, you're not seeking orders for parenting or property and parenting, it's going to be registrar managed, and a registrar is like a step down from a judge. And the attempt will be, there'll be an expectation of mediation. So sometimes they'll be referred back to, for example, legal aid or to community service. There's going to be expectation of exchange of documents early. The registrar is really going to manage that list so as to avoid delays. And adjournments are going to be discouraged, which some lawyers will despise, because some lawyers really enjoy holding on to matters and having those adjournments. So often they'll be referred off to a conciliation conference with a registrar, which I'll talk about in one moment. But a matter remains in this discrete property list with a target of 90 days, and that's the 90 days after the first court date. And after that time, the registrar will probably refer your matter off to the docket, off to a judge, and that's called the judge's docket list. And basically, judges have a docket where they hold the same matters and hear the same matters. You'll probably be referred off, as I said, to a conciliation conference, and almost every matter going through the family law courts or Federal Circuit Court will be referred to a conciliation conference. Going back to the principles of the legislation and what the court attempts to do, which is to resolve as many matters as possible without using that judicial officer. Heaven help us, the judge needs to make a decision. So conciliate, and I'm sure no judges are watching, thankfully. So conciliation conference is facilitated by the registrar. It's a really, really good, what I call reality check for the parties. So if I'm acting for a client, a property client, and their ex-partner's being unreasonable, and that might be because they're self-represented or because their lawyer is not informing them properly about what the law says and what their entitlements are. The really good thing about these conciliation conferences is the registrars generally reality check the parties. So if there's a bit of that going on, then the registrar usually puts the parties back in check around what is a reasonable property settlement. So orders will be made by the registrar before the conference, which is a timetabling of, documents to be exchanged and any proposals and so on to be exchanged. And The conferences are run on what's called a without prejudice basis. And without prejudice essentially means that if there's no agreement reached, then those discussions that take place during the conference cannot be repeated. Ultimately, if there's no agreement at the conference, although in my experience, many matters will settle at that point, but if there's not, you'll get referred back to the judge's docket, and ultimately, like I said, the judge is going to have to make a decision. The second type of property matter that I want to talk about in the Federal Circuit Court is a fairly new one, which is called the PPP 500 list: Adelaide, Brisbane, Melbourne, and Parramatta. So the PPP stands for Priority Property Pools. And this kind of links in. Remember, I was talking about a bit earlier about the legal aid mediations for property settlements between 20 grand and 500,000. This is all under that same government funding. So this government funding's come into effect, and it's also delivered this pilot program in responsiveness to family violence. And it's got to be for property matters only, so it can't be for complex matters where there's a family trust or a company, and it can't include parenting matters. But where the pool's under 500,000, there's basically this concept of a small claim process. And at the same time as introducing this concept to the court, the government introduced the funding for legal aid to run these family dispute resolution processes. And the idea behind it is to really minimise the documents that are needed. So the forms are easier. It's no affidavit or financial statement, and the need for that is waived. And I've put for the lawyers, I've put the Federal Circuit Court rule there that's waived. And there's more orders made in chambers by the registrar to avoid more hearings, which of course is to help to reduce the cost to the parties and to make things more efficient. So it's really a registrar-led process, and the matters are going to go to a conciliation conference or to an external mediation service such as that legal aid PPP 500 FDR legal aid mediation that I was talking about earlier. So that's a really good incentive, I think, and it's really designed to help those who have small asset pools to try and navigate the system themselves, because as you can sort of see through this presentation, property settlements aren't easy to try and navigate yourself. If there's no agreement, then again, it will be referred to a judge, and ultimately a judge will need to make a decision. So I'm just about to wrap up and I guess summarise that every matter is different. Your matter is going to be different, and the approach that you take to resolve your property matter is going to depend on your particular and unique circumstances. And I can't stress how important it is to get legal advice about that. And if you can't afford to see a lawyer, then, as we've got watching this live webinar, there's community legal centres that are available for you to give you that general advice and information and really arm you with knowledge and point you in the right direction around what might be the best option for you. So just to summarise as well, 1 to 6 that I gave you today were options outside of court. I'm just putting my hands there. There are many matters that can be resolved out of court, and if you can, then you should. It's very rare that I would advise a client to go straight to court because of the financial pressure, but also the emotional strain. I've never had anyone leave the court with me and say, "Oh, that was fun." It just doesn't happen. Court process will encourage negotiation, though, and there are some matters where I say to clients, look, you're wasting your time with her or you're wasting your time with him. Let's not spend your money on me trying to do this for you. Let's just go straight to court. They're the rare matters, but sometimes that does happen. But the point is that each matter is unique, each matter is different, and you need to take that into consideration. So If anyone wants to chat to me or one of my staff solicitors, we're happy to give, and this is Australia-wide, a half-hour free telephone chat. And I think the offer dropped in. The offer would have dropped into the, what do you call that, the chat box there. Feel free to book that or to send that to any of your clients. And I hope that was useful for everyone today. And I hope the legal advisors followed along with reading the Austlii law and case law as they went along, and weren't trying to multitask and do other work and check emails. But yeah, thanks everyone. I really appreciate your time. And if you've got any questions, just sing out and let me know. Otherwise, I really appreciate your time, and yeah, have a great day for those in lockdown. Okay, bye for now.